Welcome, everyone. My name is Rob Fisher, and really glad to have this opportunity to speak to all of you. We are really excited about our program this afternoon. Just a few words about how we're going to structure this. Our goal today is to really touch on the issues that we think are the hot topics, the things that employers are thinking about the most or worrying about the most. And I think the place to start right now is just the numbers. And the impetus of this program was a recognition that wage and hour litigation continues to grow at an exponential level. And you'll see up on the slide, just looking at the bottom bullet, and in 2001 there were 397 cases under the Fair Labor Standards Act, and in 2013 it was 7,764 FLSA cases. Now those are just cases in federal court under the FLSA. It doesn't even capture what's happening at the state level. Anecdotally, from my experience, I'm in Boston, Massachusetts. Most of the action is really under state wage and hour law, and we've seen a tremendous growth in litigation under the State Wage Act. So wage and hour litigation is growing by leaps and bounds, and it's an issue that I think all employers are dealing with and trying to address. Now, Sharon, you were the one that pulled together the numbers. How are things looking for 2014?
Hi, good afternoon, everyone. Yes, so for 2014, it looks like the cases continue to be on track in terms of the growth. This is based on a report from LEXIS searching all cases from January 1 until the end of April, so for 4 months. It looks like it's 2,789 FLSA cases filed across the country. And interesting to note, the area in which they're mostly concentrated in include middle and southern Florida, eastern and southern New York, southern and northern Texas, and northern Illinois. So those are just a few examples. And with Florida being the highest concentration so far, there's just in 4 months, 614 cases, and New York is not too far behind them at 530. With Texas, then it drops down to 271, and Illinois 130, and then it's just a continued sprinkle through the rest of the states in the country from there. So it continues to grow, and they're certainly on track to be as active as they are in 2013, if not more.
Hi, this is Dave Schraeger. I'm with New Jersey Wage and Hour. I noticed that you did not mention New Jersey as being one of the states. We have not, as an agency, Wage and Hour Compliance and the New Jersey Department of Labor and Workforce Development, we've not been involved in any actual litigation, or we haven't been very involved in it, but wage claims filed with our office have actually fluctuated over the years. The statistics do not show a consistent pattern of exponential increases in wage claims. In 2000, we had 7,042 wage claims filed with our office. In 2001, we had 8,455, but in 2002, we had 7,971 wage claims. We had our highest number of wage claims filed in 2008 and 2009 at 9,365 and 9,597, respectively, at the height of the economic downturn. In 2012, we had 7,373 wage claims, and in 2013, we had 8,508 wage claims. As of April 2014, we had 2,099 wage claims filed with our office. So the number of wage claims filed with our office seem to be more related to the economy in general than with any specific trend towards litigation. But I should also specify that what I'm talking about is a little different than what you're talking about, because I'm talking about an administrative wage claim versus actually going to court.
Well, thanks, Dave. I mean, from that perspective, it seems like the trend is really about court litigation. And I can tell you on the Massachusetts side, the number of filings with the Attorney General's office, which is responsible for the Wage Act, there are similar trends in that their claims are static while the litigation is actually increasing quite a bit. So I think that's pretty consistent.
Okay.
So at this point, what I wanted to do is do a very brief overview on the FLSA. Obviously, we really want to talk about some of the key issues. So again, this is really just intended to be a very basic summary, and we're not going to spend a great deal of time on it. And I suspect many of you are familiar with the Fair Labor Standards Act and its basic requirements. Essentially, the FLSA is the federal law that covers most private and public employees. It requires that employers to pay the minimum wage and to pay overtime to covered employees at the rate of 1.5 times the regular rate. I'll talk in a minute about the exemptions, but that's the basic principle of the FLSA, not including things like the child labor laws. I think the important point to remember from all of this is that the FLSA creates a floor only, and that the states are free to establish additional or greater requirements, and many of them do. And as I said at the outset, I think a lot of the action is at the state level because the states have requirements that are that may be unique, that may not be consistent with the FLSA, that are additional requirements that large national employers just may not be familiar with. David, as someone who enforces the wage and hour laws in New Jersey, do you want to just comment on how New Jersey compares to, say, the FLSA?
Well, until January 1st, 2014, the state minimum wage was the same as the federal minimum wage. There had been a push in the state to increase the minimum wage, and the governor vetoed it, so it went to a referendum, and it passed. And the New Jersey minimum wage is currently $8.25 per hour as of January 1st, 2014. In September of each year, the state will determine whether to increase the minimum wage the following January 1st based upon the Consumer Price Index. Much of our laws mirror the FLSA, but where employers have dual coverage between state and federal, we recommend that employers comply with the stricter of the two standards, which gives greater protection to the employee. And it's not necessarily the federal, and it's not necessarily the state. Employers have to be aware of which is the stricter standard and abide by that if they're covered by both.
Thanks, Dave. And the New Jersey experience is consistent with a number of states. I think in 2013, there were a handful of states that increased their minimum wage rates, and there have been 3 or 4 so far in 2014 that have done the same thing. So there is increasing disparity between the state requirements and the FLSA, such that now the real standard is dealing with the state requirements.
Sometimes that's true, yes.
So the next slide is really just laying out the basic minimum wage requirement of the FLSA. In general, non-exempt workers are entitled to $7.25 an hour. There are special rules for service employees who receive tips as part of their income. And essentially, under the FLSA, an employer must pay at least $2.13 an hour to tipped employees, with the understanding that the tips will make up the difference in the minimum wage rate. This slide is really just trying to capture the basic exemptions to the federal minimum wage and overtime requirements, and some of the more common ones, executive, administrative, and professionals. The bottom line is that employers have to show that 2 different tests are met as to those. One is a salary basis test, that the individual is paid at least a salary of $4.55 per week, and a duties test, and it varies depending on which exemption we're talking about. Another common exemption is the outside sales representative. And as David said, go ahead, David.
I'm sorry, I didn't mean to interrupt. I just wanted to point out that we did adopt about 3 years ago the federal FLSA overtime exempt criteria for executive, administrative, professional, and outside sales. But only outside salespeople are also exempt from minimum wage under the New Jersey State Wage and Hour Law. Executive, administrative, and professional exempt employees are only exempt from overtime, but not from minimum wage. I apologize for interrupting.
No, that's fine. I was going to invite you to offer that point.
Get that point in. So that is one difference where we are stricter in terms of the minimum wage for certain exempt criteria.
And Massachusetts is the same way in that the state generally follows the exemptions for purposes of overtime, but not for minimum wage, which does create some interesting results because the state rules for minimum wage are fairly unique. So this is really just intended to cover some basic concepts under the FLSA, things that we'll be talking about more in depth. The first is the idea of the work week, which is important in calculating overtime and determining whether or not an employee has worked more than 40 hours in the work week. And essentially under the FLSA, the work week is any 7 consecutive 24-hour periods as established by the employer. Another key concept is hours worked. It's the time that the employee is on duty or on the employer's premises engaging in his or her job duties. And the question that comes up, and we'll talk a little bit about some of the donning and doffing cases, is is time in advance of those basic duties compensable or not? And lastly is the regular rate, and that's a regular rate can be more than just the wage rate. It can be any payment to the employer subject to certain exclusions of the statute, and that again comes into the calculation of overtime. Essentially, this is just putting forward the civil enforcement scheme. The Secretary of Labor can bring an action against an employer for back wages and liquidated damages, but obviously an employee can bring a private right of action as well, and also seek liquidated damages. From my perspective, most of the action is really in the private right of action world. It's not there aren't that many DOL cases, and so that I think the civil enforcement, the private right of action, is the more important from my perspective. So now we're going to really get into the substance of the program, and we're going to talk about some recent decisions addressing wage and hour issues. And I think an important place to start is in the donning and doffing world, which is really intended to capture the time spent before beginning the work activity such as putting on protective gear, putting on special clothing. There's a lot of litigation in this area, and an important place to start is the Supreme Court's recent decision in Sandifer versus U.S. Steel, which is a donning and doffing case. Now, Sandifer involved a very unique set of facts in that it came under a specific provision of the FLSA that essentially says the time spent changing clothes or washing at the beginning or end of the workday is compensable unless in a collectively bargained environment, the union and the employer bargain for a different rule. And that's what happened here. U.S. Steel essentially bargained with the union that time spent putting on protective gear was not compensable time under the collective bargaining agreement governing U.S. Steel's employees. Some of the employees brought a lawsuit saying that's not changing clothes within the exclusion and said that they were entitled to compensation for that time. So effectively, the question before the Supreme Court was, is the putting on of the protective gear covered by Section 2030, this unique provision in the unionized context? And the court said that some of the gear was in fact clothing because they were items that were designed and used to cover the body, and that putting it on was in fact changing clothes. So the court basically says, as to the stuff that the protective gear that is clothing, that those clothes, that gear, you can't get compensated for that time. So from the unionized world, I think that's a very important development. It makes it clear that to the extent that the prep time involves putting on protective gear, that can be something that can be bargained as excluded from employees' pay. The larger takeaway, I think, from Sandifer is what the court says as to the other gear, which it said wasn't clothing. And even then, the plaintiffs didn't have a claim. the court went out of its way to say, look, the federal courts aren't in the business of being time study professionals. We don't want courts spending a lot of time trying to measure very, very small amounts of time. And the question really is whether the period as a whole can be characterized as compensable or not, and concluding that the non-compensable gear was a small portion of the total amount of time spent, the court said the plaintiffs didn't have a claim. So as an employment lawyer, I'd like to think that the message, the takeaway from Sandifer is that courts are going to take a hard and fast rule, a hard look at these cases and think about practically, is this the kind of thing that the federal courts need to worry about? Is this such a small amount of time that it's not reasonable for either the courts or employers, for that matter, to be worrying about it? And you get a flavor of that in the next case that's on slide 15, which is Mitchell versus JCG Industries. So this is a post-Sandifer case. It doesn't involve the 2030 exclusion. Instead, it was donning and doffing sanitary gear at the beginning and the lunch break. And the majority for the Seventh Circuit affirmed summary judgment for the employer on the theory that this is not the kind of thing we think employers should have to worry about. It was a very small amount of time. And so the language that I like in particular is that common sense has a place in adjudication of the FLSA, and that we don't want employers to have to engage in the onerous and futile task of calculating very, very small amounts of time across a workforce. So I think the message from Sandifer, and that it's reaffirmed in Mitchell, is that these donning and doffing cases have to be a significant amount of uncompensated time for it to survive in the federal courts. At least I'd like to think that's the message. Now Sharon, as someone who deals with donning and doffing issues with your own company, how do you see, from a compliance standpoint, what do you think are the best practices for employers to think about?
Well, first and foremost, I think that companies who have a workforce that include unions, they could rely on the Section 2030 of the FLSA in terms of the exception that the time needed for donning and doffing would be exempt, and it is really up to what management and the union negotiate as to whether donning and doffing would be treated as compensable time, or alternatively, it depends on the custom and practice at the facility. That works, and it's helpful to an organization where you could be confident that the Fair Labor Standards Act, the federal law, would apply. My cautionary point is that we should not forget state law as well. And there are certain states that have decided the issue as to whether Section 2030 similarly applies under their own wage and hour laws, if it would recognize the same exception, and it differs. And then there's other states where they haven't made that decision. So it could be a little bit dangerous to rely wholeheartedly on that section if that particular question has not been heard by a court, or expressly, or the exception has not been expressly made in a state wage and hour law. So again, it's something as it is in any wage and hour matter. It's important to appreciate, of course, not only the federal law, but what does the state law required in any particular area, and donning and doffing is certainly one of them. Another just best practice tip as it relates to donning and doffing is to be cognizant of what exactly are the types of activities that an employer is asking its personnel to perform in preparation for their shift. Is it critical? Is it indispensable to them performing the job? Because if it is, that probably would be viewed as compensable time, again, subject to whether 2030 applies. So if a company wants to be cognizant over whether they're going to enter into this potential area of donning and doffing, they need to pay close attention to what are the sorts of activities employees are doing and whether, in fact, the organization believes they're indispensable or not, because that in and of itself could be an area of dispute. The other point that I wanted to make was the issue of whether changing of clothes should be done at the facility or is it something that could be done at home. And that would weigh into, again, whether the time changing is considered working time or not, and what options do employees have as it relates to uniform changing. But I think ultimately it's just stepping back and looking at this precise issue to be prepared and understand that if currently your organization is not compensating for time that could be viewed as indispensable to preparing for the shift or even the doffing, the post activities, there could certainly be liability there.
Sharon, thank you. Those were all great points. So now we're going to move to a related issue, but it's not a donning and doffing issue, but it's time spent waiting to leave the employer's facility after the employees have clocked out for the day. And the case is a case out of the Ninth Circuit, Busk versus Integrity Staffing Solutions. The case involved warehouse workers for a staffing company that essentially that the employees were filling Amazon.com orders in a distribution center. And the way it worked is they would clock out, and then according to the plaintiffs, they would spend up to 25 minutes at the security check before they could leave the facility each day. And they argue they should be paid for the time spent waiting at the security check. The trial court said that the time wasn't compensable on the theory that that's just essentially home, that's not part of the employee's regular job, it's not integrated with their job duties, it's really just work to home travel, which generally isn't compensable, but the Ninth Circuit disagreed. And the way the Ninth Circuit concluded that it was related to their work was based upon where the security check was, which was the employees didn't have to use the security to get in the facility, only when they left, and it was obviously designed to prevent employee theft of merchandise. And what the Ninth Circuit said is because of that, it stems from the nature of the work and it was compensable time. I think this case is incredibly important because I know a lot of employers utilize security procedures to prevent employee theft, and this really would, if the Ninth Circuit decision is good law, it really would change the analysis because it's very typical for people to clock out first and then go through security. The case, the Supreme Court has agreed to hear the case. We expect to get a decision on the issue sometime probably in the spring of next year. And I'm sure, if LexisNexis does another webinar on wage and hour, I'm sure that will be a highlight of the program because that's going to be an important case on what does it mean for something to be related to the employee's principal job duties. So that's we'll have to wait and see what happens on that. The next case, which is on slide 17, Griffin versus S&B Engineers, I included because I think it's a good reminder about travel time. From my experience, employers have a lot of confusion about when employees are entitled to compensation for travel time. And by employees, I'm talking about non-exempt. And in some ways, the DOL's rules on travel time are in some ways counterintuitive. And I think employers and employees, frankly, are confused as to when they are entitled to time spent traveling to the workplace. Generally speaking, travel from home to work is not compensable. But if they have to travel away from their normal work location, whether or not it's compensable really depends on when the employee is traveling. So Griffin adds a different wrinkle, which is essentially the employer had a process by which employees had to park their vehicles in one location, and the employer was busing the employees, and this was mandatory, to the work location. And the employees brought a lawsuit alleging that the time spent on the bus was compensable travel time. At the trial court level, the employer won summary judgment, and the Fifth Circuit ultimately affirms that. The plaintiff's basic argument was that there should be a per se rule, that if the employer is going to make us go through this process, they should get paid for the time. And the Fifth Circuit said, no, it's It's going to be a factual inquiry about what it is the employees are being required to do, if at all, on the bus. And so ultimately in this case, the facts were that the plaintiffs, they got on the bus, the time was theirs. They weren't given any work instructions, they weren't asked to do any work, and the court concludes that that was really just part of home to work travel, not compensable. And so one of the things you want to think about if you have any sort of travel process by which employees need to travel from one location to another, if it's just arriving at the work site, you've got to make sure that they're not being asked to do anything, they're not giving any instructions, and that they can spend the time any way that they want to. The next case I want to just touch on, which is a case that came down about 2 months ago out of the First Circuit, is Newman versus Advanced Technology Innovation. This is a case that I think is really important because it deals with the question of regular rate. And we talked a little bit during the overview as to what regular rate is, and I mentioned that in general it's anything the employer pays subject to certain exclusions. One of the exclusions in the FLSA is reasonable payments for travel expenses. So those generally are not included in an employee's regular rate. Now, Newman involved a situation where the employer paid a per diem to cover reasonable travel expenses, but if the employees work less than 40 hours in the work week, it would prorate the amount of the per diem based upon the hours worked. They brought a lawsuit saying the per diem should be counted in their regular rate and then thus would be a part of the calculation for overtime. The trial court disagreed, granted summary judgment to the employer. It went up to the First Circuit. The First Circuit, relying on the DOL handbook, so it's not a regulation, it's not in the statute, it's just the DOL's handbook that says if the per diem is calculated based upon the number of hours worked or varies by the number of hours worked, then the payments become part of the regular rate. And the First Circuit says we're going to follow the DOL's handbook on that issue. And not only did they reverse summary judgment for the employer, they order the trial court to enter summary judgment for the plaintiff on the theory that the employer's calculation of the per diem by looking at employees' hours meant that it was tied to hourly compensation and thus was part of the regular rate. So this case is a very good reminder that that the wage and hour laws are highly technical, and that the general rule would say the employer was doing it exactly right, but the DOL's guidance on the issue suggested otherwise, and it just shows how that employers can violate the statute even when they intend otherwise. And it's a good reminder that things like travel expenses can be included in an employee's regular rate.
Rob,
yes.
I don't know if I misunderstood something here when I was going over it, but there are employees who are paid per diem pay who are non-exempt, and if their regular pay is a per diem rate, if they're non-exempt, it doesn't make the employee exempt from overtime, and employees are required to keep a record of the hours actually worked by non-exempt employees because they are entitled to overtime if they work over 40 hours in a week. And the per diem rate must cover them for at least minimum wage, which is $8.25 per hour in New Jersey as of January 2014. But it looks like the slide is actually talking about a per diem travel expense. Is that right?
Correct.
Is that what you're talking about?
Just
Okay.
by clarification, the per diem, so these employees were paid an hourly rate for their time, and it was pretty substantial. It was somewhere in the $30 an hour range.
Right.
And then on top of that, they were given a per diem that assumed that they would have so much travel time each day and each week. And if they weren't, and so it was a flat rate, but if they work less than 40 hours, the employer would prorate it on the theory that they weren't traveling as much during the week because they didn't work, they weren't working the full week. Yeah. The mistake there was that the employer was prorating it by hours as opposed to days.
That makes it part of the rate, right?
Correct,
because
exactly.
We generally regard reimbursement of travel expenses as a fringe benefit, which would not be included in an employee's regular rate of pay. But when you tie it to the hours worked, it does become part of the hourly rate.
And that was the Department of Labor's position regarding regarding the per diems in this case. We have a question from the audience which relates to this particular case, which is a question about what's the DOL handbook. So the Department of Labor has a lot of guidance out there, which includes a field handbook which provides a tremendous amount of direction for employers as to at least how the DOL interprets the statute, and gives some very useful guidance on how the Department of Labor has interpreted certain things in the past. So that's accessible from the Department of Labor website.
And we also have FAQs on the Department of Labor and Workforce Development website, and our laws are also on the website. The New Jersey State Wage and Hour Law, the Wage Payment Law, Child Labor Law, etc.
The next case I want to talk about is Sander versus Light Action, and we included Sander because it's a good reminder of the salary basis test issue for exempt employees. As I said earlier, the salary basis test for administrative, executive, and professional employees is that you've got to pay them at least $4.55 a week. One piece of that test is that you can't engage in improper deductions from a salaried employee's weekly wages based upon, say, partial day absences or other deductions that are improper. And so you can destroy the salary basis test by essentially treating a salaried employee as an hourly employee. And the Sander case is a good example of why employers need to worry about that. Although the case ultimately comes out favorable to the employer, it's a case that ultimately went to the Third Circuit. This was an employee who was paid a weekly base salary that was above the $4.55 per week, and she was entitled to additional compensation depending on certain off-site work that she did, and also for working hours in basically more than 45 hours in a week. So she got extra pay for extra work. And she argued that because the additional compensation was determined by looking at her hours worked, that she effectively was being treated as an hourly employee as opposed to a salaried employee for purposes of the administrative exemption. The Third Circuit ultimately found that the employer was in the right because she always received her regular base salary regardless of how much she actually worked. That was the base, and everything else was just extra compensation. But again, the case is a very good reminder that that if an employer alters the pay of a salaried employee, you could be destroying the salary basis test and the overtime exemption. So that's just something to keep in mind. The next case, Blanchard, is really just here as an example of the continued, what I think of as substantial litigation regarding whether or not individuals are truly exempt within either the executive, professional, or administrative. And there are a couple of things that come out of the case that I think that are good reminders. One is, we tend to think of wage and hour cases as class actions or collective actions. You know, individuals will bring a claim on behalf of everybody in the same job category and argue that the particular job category really was misclassified as exempt when it should have been non-exempt from the overtime requirements. In this case, this wasn't a class action. This wasn't a collective action. This was an individual who said that his job, Director of Institutional Sales, was misclassified as exempt, and the court the court goes through what he actually did and concludes that he was within the exemption and he was appropriately classified as within the administrative exemption. A couple of things that come out of the case I think are useful is one is that the court's really in the weeds as to what he's doing and has nothing to do with the job description. I think oftentimes when employers will come to me and say, can you tell me whether this job is exempt or not, what they provide to me is a job description that may or may not reflect what people are actually doing. And this case is a good reminder that it's not the job description that matters, it's what people actually do, what's their primary duty, and do they actually exercise independent judgment and discretion. And so to those of you who advise employers or represent employers in these areas, the question is not just what the job description says, although I think that's important, but it's not dispositive. And so it's a reminder that you want to look at these things carefully, and I also believe that it's not a static process, that employers need to be revisit these issues from time to time. And in fact, I think every employer is going to be faced with having to revisit their overtime, the exemptions very quickly. For those of you who followed the State of the Union address this year, President Obama made it clear that he was going to use his executive authority where possible to change the wage and hour laws. And the one place that he did that is that in April, he instructed the Department of Labor to, quote, modernize and streamline the overtime regulations. And the White House issued a fact sheet, which I think is interesting because one of the things that the White House is focused on is the salary basis test. It's pretty clear to me that the DOL will increase the 455 amount to some higher number. The White House seems concerned that only about 12% of salaried workers are actually below the 455 threshold. And when you compare it historically to the salary basis test, it was a much larger percentage of salaried workers. So I anticipate that that's going to change. We should get proposed regulations sometime in the next 6 months to 9 months, from what I'm hearing, and ultimately we'll get final regulations. I don't think it's going to be limited to the salary basis test, but I do think that employers will need to review their job classifications, particularly those jobs that are on the cusp between exempt and non-exempt status. At this point, we're going to switch gears and talk about one of the specific topics that we think is really at the forefront of wage and hour litigation, which is misclassification of individuals as independent contractors rather than employees. And I think most people, when you ask them about who's an independent contractor versus an employee, they think of the IRS test, which is this multifaceted test that looks at all of these factors and decides whether the relationship looks more like an independent contractor relationship versus an employment relationship. And one of the first things the one message I want to send is the FLSA has a very, very broad definition of employment that's broader than the IRS test. So to the extent that you're advising employers or you're dealing with employees who are looking at this issue from the IRS test, I would submit that's not the way to look at it for purposes of the FLSA. The FLSA basically says that employee is anyone employed by an employer, and that's somewhat of a tautology, but then it goes on to say that employee means to suffer or permit to work. And the courts essentially are using an economic realities test and looking at a handful of factors and looking at whether or not it looks more like an employment relationship versus an independent contractor. This is again, this is a test that I think is more stringent than the IRS test. So technically, you could have a result that somebody might be an employee for FLSA purposes, but who is not an employee for IRS employment payroll purposes.
Well, we tend to agree with the U.S. DOL definition of employee in the economic reality test, but in New Jersey, the Attorney General's office has determined that unemployment is the lead agency in New Jersey to investigate possible misclassification of employees as independent contractors.
Thanks, Dave. And I think that's actually a really good segue to the next slide, which is, from my perspective, and I know Sharon agrees with this, I don't see that the law has changed much in terms of who is an employee or independent contractor for wage and hour purposes. What has changed is that the Department of Labor has made it absolutely clear that misclassification is a priority of the agency. They've established a task force with other agencies in the federal government to look at this issue. It is both a revenue issue for the government, but it's also a philosophical one, which is that there are individuals who are misclassified, who are being deprived of basic rights under the employment laws, including the FLSA. What we're seeing is continued, well, we've seen the DOL take a very aggressive position on these issues. They've brought a number of enforcement actions. And the states are working closely with the federal government in this issue to identify misclassification. So from my perspective, it's not that the law has changed, but the enforcement level has been turned up a notch. And then to Dave's point, you've got to look at state law as well. Definitions really matter. So I come from Massachusetts. As I said, the statute here is incredibly stringent. I think it's probably the most stringent in the country. It essentially holds that an individual is presumed to be an employee unless the employer can prove otherwise. And it is a very, very difficult test to meet, that the individual has to be free from control and direction, the service performed is outside the usual course of business, and the individual has his or her own independent trade, profession, or business, what I call the Yellow Pages test, to the extent that anyone actually uses the Yellow Pages anymore. So the real challenge from, like for example in Massachusetts is, can you even have, should companies even try to have independent contractor relationships anymore? Now Sharon, from a national perspective, where do you see employers going on this issue?
Well, I've had the opportunity to discuss how various companies are managing this risk because depending on the size of an organization, compliance departments or legal departments may not always have the best control over what your everyday managers are doing. And frankly, HR may not necessarily have oversight or control over various retention of independent contractors and therefore really lose visibility over the sorts of support the organization is retaining, especially in the area of independent contractors. So depending on a company's decision and their risk tolerance, I've spoken with other in-house counsel who have taken quite an aggressive approach where they have completely banned the retention of independent contractors, independent consultants, and require that any such services be provided through staffing agencies, so at least there is an employer, quote, employer in the picture paying taxes and ensuring proper classification. Alternatively, companies would require the consultant to be incorporated, and so not only are they themselves forming their own, for example, limited liability corporation, and therefore, are required to pay their taxes, but the other advantage to that is that hopefully they're also getting insurance for the company, and that helps to protect them and their assets to the extent any of the services that they're providing, the third party results in some type of liability. So, it depends on the nature of the company and how rogue managers are in terms of hiring independent contractors. But like I said, if you're in a more conservative, risk-adverse organization, this is what I'm hearing. This is what I'm seeing in terms of companies just frankly not permitting the retention of independent contractors in that way.
Thanks, Sharon. I just want to comment on one thing that I can tell you in Massachusetts, the issue of having individuals form their own businesses and have their own insurance, that's somewhat been turned on its head. There's a fair amount of case law on this issue where the fact that the individual might have his or her own business is not dispositive, and the fact that they might have bought workers' comp insurance goes to damages, not to, it doesn't prove independent contractor status. So again, we have a very stringent test up here in the Commonwealth. We're now going to switch gears and talk about the topic of unpaid interns, and Sharon's going to take the lead on that.
Okay. Okay, so this has become another hot area of enforcement. And I think most recently, at least in 2013, it has gained some attention because of a particular case that came out of federal court in New York. But before I get there, it's a catch-22 situation whereby, on the one hand, the law is there to obviously protect employees or individuals from having worked for free. On the other hand, it has arguably a negative impact on, for example, students coming out of college or who are in college and are, when we're in a down economy, that are just appreciative to have any experience, get their foot in the door, and have an opportunity to network and have whatever exposure they have. With limited budgets, companies may not be as inclined to hire paid interns and look forward to unpaid internships. So that's the dichotomy that's going on in terms of the willingness and the need for, example, the students to get that type of experience, but yet you have regulations that require interns in certain circumstances to be paid. So this is another hot area in the wage and hour world. Ultimately, the premise is that an employer has to pay its workers unless it fits a specific criteria. But that specific criteria is very narrowly construed. What's helpful to companies is a fact sheet that came from the Department of Labor in 2010, and an employer would be required, a for-profit employer would be required to demonstrate 6 criteria according to the fact sheet. First and foremost, the internship has to be similar to a training in an educational environment. The internship has to benefit the intern. The intern does not displace regular employees. The employer derives no immediate advantage from the internship, and occasionally the activities may be impeding the employer because of the investment it's making in training these interns. The intern is not entitled to a job at the conclusion of the internship, and the employer and the intern understand that the intern is not entitled to wages. Some other factors, too, is in terms of job shadowing, that could be permitted. Again, it really depends on the totality of the circumstances, but certainly in terms of shadowing, that intern really should not be performing any work because otherwise it wouldn't be a true job shadow. Again, if the intern is doing some work and is being supervised as a result of it, it probably won't qualify as job shadowing. It's also helpful to demonstrate that the internship is for a fixed duration and there's no expectation of hire. I can tell you from the perspective of a best practice is, and it really just depends on the varying types of internships a company might, internship programs a company may develop, but a good start is to take these 6 criteria and make sure that obviously your organization or your clients are following it, and to have an offer letter to the unpaid intern making sure that certain of these understandings are reflected in that agreement. So there can't be any expectations on either side. One area that recently was challenged, I'm sorry, Robert, was that you?
No, that was me. I wanted to just say something before we moved along.
Sure.
We generally agree with the 6 criteria used by the USDOL, but we look at unpaid internships on a case-by-case basis, and normally it is our position that an unpaid intern must receive something of value, such as educational credit.
Yeah, I will. Well, being a New Jersey employer, I actually very much appreciate the New Jersey regulations. And again, this is just another reminder. This is an additional area where you can look at the fact sheet from the Federal Department of Labor. But
Yes.
it's important to also look at what the state requirements are because they could be more stringent. When I look at the New Jersey requirements, I appreciate them because they seem to me a bit more black and white, and so in our organization, we require that there be a connection to a university, and they have to get class credit to have an internship. So, and the way that we've been interpreting specifically the New Jersey regulations, we're interpreting it in that way because of how they're written. So it's helpful. And again, it depends on the corporation and the industry they're in, and certainly the state that they're in. But if they want to ensure that this is an area that they don't run the risk of possibly misclassifying the individual as an unpaid intern, they should definitely try to mirror the criteria that the Department of Labor or the state Department of Labor has adopted. Recently, the DOL was questioned through the American Bar Association specifically about law students and whether working on pro bono matters in a private law firm would qualify for an unpaid internship. And the solicitor, Ms. Patricia Smith, advised in a letter through the ABA that a law student could participate in an unpaid internship if 5 conditions are met. And you'll find that they do somewhat, in some areas, overlap with the 2010 fact sheet. First, the individual has to exclusively be working on non-fee generating pro bono matters. The program has to be structured to provide the student with professional experience in furtherance of his or her education. The hiring of an unpaid law student interns does not displace regular employees. Law student is not necessarily entitled to a job at the conclusion of the internship, so there we see the connection there. The court also found that ultimately the production companies were getting the immediate advantage of these interns' work. The interns themselves received nothing related to education. They didn't get any, there was no tie to the school, whether some other course that they would meet once a week, talking about their experience and what they learned on the job. And of course, more obvious was that they didn't get any course credit either. Now, there was the argument that certainly the interns are getting the benefits of being on a production set and whatever tasks they were performing, the knowledge of how production works, and specifically the accounting office and the networking and the connections they made for potential future opportunities. But what the court found there is that, again, that's no different than what a regular employee would benefit from working. The court also recognized that there was no unique program. There wasn't something special designed for these particular interns to ensure that that this work was tied to some educational benefit. They just ultimately performed routine tasks that other employees would otherwise perform. The court also went into an analysis because of the argument made by defendants that they would fall under a trainee exception, and that the trainee exception was defined under a much earlier Supreme Court case, Walling versus Portman Terminal Company. It's a 1947 decision, and that dealt with a railroad company who offered a week-long training course for prospective brakemen. So again, just to note the perspective. And these were unpaid because they were considered trainees. And in that case, it kind of set the standard or definition for who would qualify as a trainee. And what the court found is these trainees did not displace regular employees. The regular employees actually did most of the work, but the trainees themselves, it didn't impact the scope of work of your regular employees, whether the trainees were there or not. The trainees did not expedite the company business, and actually because of this program that the railroad company designed, it actually impeded the company because of the investment in time it made in developing and conducting the training. The court found that the railroad received no immediate advantage from any of the work done by the trainees. So that was the analysis in the GLAT case to distinguish these interns from the trainee exception. This case is currently on appeal in the Second Circuit Court, so it's something to look forward to see how the Second Circuit is going to rule on this decision, because it really just took the DOL six-factor test. This other decision, Wang versus Hearst Corporation, so this actually came before the GLAT decision. This also dealt with unpaid interns out of the Southern District of New York. It's a class action where the plaintiffs alleged that they were improperly classified as unpaid interns and owed wages. The court denied the plaintiff's motion for summary judgment as class certification. Now, in this case, the court relied also on the six-factor test and found that you really need to look at the totality of the circumstances and who's the primary recipient of the benefits from the relationship. Hearst showed, so the company Hearst showed that there was some educational training and there was some benefit to individual interns. There was some supervision and some impediment to Hearst's regular operations, etc. But ultimately, the court found that a jury could return a verdict in Hearst's favor. So that, too, that case is also on appeal with the Second Circuit. There are many other cases relating to unpaid intern issues and even volunteer cases, and I think it just demonstrates that this is a hot area. It's a sign of the times, especially with the down economy. And if your organization or your clients don't have this on their list of what to be wary of, because internships are pretty popular, especially with the upcoming summer months and students being off from school, really need to pay attention to the programs and how these individuals are performing the work. There are a few other New York complaints that were filed after the GLAT and the Wang case. I didn't get into the specifics here, but I do think they're very much tied as a result to the GLAT decision. Certainly, you'll have these copycat cases and in the area, and you'll see it by industry. So where you have interns working on movie production sites or television, you'll see that that becomes a hotbed. But again, I don't think any industry will be immune. Especially given the notoriety that these types of cases are going to have in social media. But there are these other decisions that, or other complaints, sorry, that are coming down the pike in New York. Additionally, there's this DeMaio versus Palms West Hospital case from the Southern District of Florida. And there, I just wanted to offer everyone a couple of cases where the internship was actually properly classified as unpaid. So here are a couple of examples for those who need it. Here the court determined that it was an unpaid, that the unpaid extern working at the hospital was not an employee. She was required to complete an externship and certain surgeries as a prerequisite to graduating, and she understood that the externship would not result in employment, and there was no corresponding staff reduction as a result of the work that she performed, and the employer monitored her work. So there you have that case. The other one is from the 11th Circuit, 2013 decision, Kaplan versus Code Blue Billing and Coding. The court held there that the intern plaintiffs were not employees. They did not displace regular employees. They performed work towards a formal degree program, and defendants supervised and trained plaintiffs in a manner which required it to take time away from the business. So there it was impeding the business. So those are a few cases there that held the other side. See. Robert, with the heightened attention in the area of unpaid internship, if you do have a client contacting you and they're in this catch-22 situation where on the one hand they don't have the budget to, quote, hire the headcount, but at the same time they want to offer these opportunities to interns, how do you counsel them?
So I represent a lot of tech companies, so this comes up quite a bit. So startup companies, they don't have a lot of cash. It's incredibly popular to hire recent grads as quote-unquote interns. And you know, whenever I try to give some advice on this issue, I always get the, well, everybody does it this way defense, which isn't a defense. So the bottom line is incredibly hard. In the first instance, I always recommend if you're going to bring somebody on, pay them at least the minimum wage. If they can't do that, then the question becomes, how do you structure this to look more like an educational training program? One of the things I always say is work with a local university or other institution of higher education, come up with a program, and think about in advance what the program is going to look like. Don't just bring somebody on as a quote-unquote intern and have it set up where they're just going to do whatever it is you need to have done. Think about what it is that you're going to offer the internship. And you know, the challenge, I think, is that as soon as I give that advice, it's typical for the company to say, well, we're not looking to build a program where we're training people. We're just looking for people who we essentially what I view as a temp to perm arrangement. They want to bring people on, try them out, and if they work out and they have the money for it, bring the people on as an employee. And if that's what they want to do, I just tell them there are some significant risks in doing that.
Yep. Okay. All right. Well, I think we should probably keep going forward, and I'll kick it off to you, Robert, to cover the collective actions and class actions.
Thank you. So we can't talk about wage and hour without talking collective action and class actions. By way of background, the FLSA is somewhat unique that it has a collective action procedure, which in my mind is the reverse of a class action, in that individuals have to opt in affirmatively into the litigation to be members of the class. And essentially there's a two-stage certification process where the plaintiff has to show that he or she is similarly situated with other current and former employees and that they were all subject to the same policy or plan. Typically notice, if that's granted, notice is given out, and then individuals have the right to opt in. And then after that process is done, the employer has the right, after some discovery, to try to move to decertify the collective action. So I really, the mechanics are different, and the thing I wanted to talk about is that there are a couple of cases that really, I think, highlight how because the mechanics are different, it creates some procedural opportunities for employers. The lead case is this Genesis Healthcare Corp versus S.Ct case. The plaintiff brought a collective action of the FLSA, essentially alleging that she and other employees were deprived, were basically, they had 30 minutes deducted for a meal break, but they were asked to work during their meal break such that they should have gotten paid for the time. The employer made an immediate offer of judgment to the named plaintiff, essentially saying, we're going to give you full recovery plus attorney's fees as an offer of judgment to make the case end. The plaintiff ignored the offer of judgment, but then the employer then took the position that the case was moot because the named plaintiff had been offered complete relief. The case went up to the Supreme Court, and the Supreme Court held in S.Ct that the case was that where other employees had not yet opted in, it was just a single plaintiff case, the lawsuit was in fact moot when the employer offered complete relief as an offer of judgment, and the plaintiff no longer had a personal interest in representing others. And that was the case even though that there wasn't actually a determination of collective action status at that point. So it creates an opportunity for employers in FLSA cases, particularly those where the alleged damages are easily calculable, to immediately make an offer of judgment. And even if the named plaintiff rejects that, it becomes a basis by which you can prevent the collective action procedure from occurring. So I think that's a really important thing to think about. It's an important tool that employers can now utilize. Where I see the fight coming is going to be whether or not the offer of judgment truly is complete relief. I expect that plaintiffs' lawyers will be creative in how they allege damages in an FLSA collective action complaint as a way of making it difficult for the employer to offer complete judgment to the named plaintiff. But again, this is a case that I think is very important because it allows the employer to essentially take away the collective action process altogether from the case.
Robert, if I may add, in New Jersey, as per the wage payment law and the wage and hour regulations, employees must be completely relieved of duty in order for that time to be non-compensable. If designated break periods are interrupted and employees are performing work, that time is compensable. And if we find that to be the case, without having to go to court, and it's an undisputed fact, it doesn't have to be litigation. We would require the employer to do a self-audit and pay the back wages for the time that wasn't, for the work time that wasn't paid.
Yeah, that's a good point. That this assumes that the case, that these kinds of cases get resolved, that go to litigation, as opposed to are resolved through a governmental investigation process. So that's a good point to bring up. The other interesting procedural case I think we should talk about is the Kamisi versus West Penn Allegheny Health System case. This is a case where procedural wrangling backfired on the plaintiffs. They had brought a collective action. The trial court initially certified the case as a class action, but then decertified it after doing a more thorough review of the case. And in the context of, because the court did that and because there was no immediate right to appeal that, normally the plaintiffs would have had to go into trial, get a final judgment, and then appeal. They dismissed with prejudice their individual claims in order to seek immediate appellate review. The Third Circuit held that it lacked jurisdiction to hear the case, that because the plaintiffs were essentially trying to short-circuit around the presumption against an interlocutory appeal, the plaintiffs' voluntary dismissal basically killed both their individual claims and their representation interests. So, again, the collective action procedure in some ways is much more friendly to employers than the class action procedure, and as a practical matter, the decertification motion is incredibly important because at that point, if that should happen, the plaintiff generally has to go to trial on the case as a single employee case, and then appeal the final judgment to go to have the Court of Appeals review the decertification of the collective action. So it's a reminder that oftentimes the plaintiff's lawyers don't actually want to go to trial on a case for an individual plaintiff. So now I want to talk about class action. So if you've got a state law claim in federal court, a state wage and hour claim, it's governed by Rule 23 as opposed to the collective action requirements of the FLSA. And I put here on slide 37 the basic rules of Rule 23. You've got to meet all the requirements of 23A, numerosity, commonality, typicality, and adequacy, but also meet the requirements of 23B, which the most common is B3, with that common questions of law or fact predominate over individualized questions, and that a class action is the superior mechanism for resolving the case. You can't talk about class actions without talking about two very important Supreme Court decisions that have come down the last couple of years, neither of which is a wage and hour case, but because they're interpreting Rule 23, it certainly interprets how the federal courts are going to apply Rule 23 to wage and hour cases. Now, I should say these cases are purely cases interpreting Federal Rule 23. They don't apply to State Rule 23. And one of the things I've seen is that it just solidifies the general desire of plaintiffs and plaintiffs' counsel to be in state court as opposed to in federal court. And the rules in state court may be very different. And I can tell you for here in Massachusetts as well as California, the rules on how to interpret when class actions are appropriate, I think, are more lenient than the way the federal rules are, particularly after Walmart Stores versus Dukes and Comcast. Now, in Walmart Stores versus Dukes, which is slide 38, the court, again, not a wage and hour context, but basically gives out some basic principles about how the court should be interpreting Rule 23. Which I think are very, very useful in setting the tone as to how courts should be looking at class action issues. One is that Rule 23 is more than a pleading standard. The plaintiff actually has to present sufficient evidence that the rule has been satisfied. Second, the court uses this language that says that the trial courts have to engage in a, quote, rigorous analysis, and virtually every subsequent case that's talking about what Dukes requires uses that language. And I think that really signals what it is that the Supreme Court expects of the lower courts, that class actions are an exception to the general rule that the parties to an action are the named parties in the case. And the specific issue in Dukes dealt with commonality, one of the requirements of Rule 23A, and essentially what the court says, Justice Scalia writes that a common question is not some generic one. In the Walmart it was everybody discriminated against? And what he said is that the question has to be significant enough that the answer it generates actually drives the resolution of the litigation as a class action. So it has to be a question that actually you get an answer that's useful for actually moving the case along. And in his view, the majority's view, just the generic question of was everyone a victim of discrimination didn't really do that. So that's Dukes. Then you get Comcast versus Barron, slide 39. And Comcast is focusing on predominance, Rule 23b3, and essentially what the court says there is class certifications improper where individualized damages calculations will overwhelm common questions. And specifically, in that case, the plaintiff's damages theory didn't match up with their theory for proving liability on a class-wide basis. The Court of Appeals basically said, well, that's a merits question. We're not going to deal with it. And the Supreme Court said, no, that's not a merits question. That's a Rule 23 question that you actually have to think about in assessing whether or not class certification is appropriate and whether or not predominance has been satisfied. So as I said, those cases are not wage and hour cases, but they absolutely apply to the certification of state wage and hour claims in federal court. And the thing that I find fascinating, particularly after Comcast, is virtually every wage and hour class action is going to require some element of individualized proof of damages. It's just the nature of these cases that you're going to have to prove that on a person-by-person basis. There have been a number of cases that have come down post-Dukes and post-Comcast that address this question, and where I think they come down is, and the way to explain them simply is that if all we're talking about is some arithmetic calculation or proof of damages based upon documentary evidence, then that doesn't displace the appropriateness of class certification. The question then is whether damages is going to require a more complex determination. So from my perspective in defending these cases, you still want to focus on the number of individualized issues on the liability questions, but you really want to show that the plaintiff's damages theory really requires more than just some arithmetic calculation. And then again, lastly, the state courts have their own rules, and so while I think the message from the federal court side is very positive, the state court rules are their own rules, and so how a state court is going to certify a case of a class action may be very different. And now we're going to move to our last topic. Sharon's going to talk about responding to a governmental audit or investigation.
Okay, great. Thanks, Robert. So I will I'll get through this real quickly, and hopefully we can have some time left in the end to answer some great questions that we've been receiving. All right, so I think in a perfect world, if you can invest resources and convince management in your organization, if you serve as in-house counsel or in representing as an outside attorney, to do internal audits. That is the best way to prepare yourself for any potential audits by the Department of Labor or any lawsuits. Certainly, you want to build systems, practices, policies that are in compliance. And again, it's a question of how your organization is structured in terms of the amount of control and oversight that goes into managing compensation and hiring of employees and their classification. And you know, companies do make mistakes. People make mistakes, and the key is how do you get ahead of it? So, of course, doing internal audits could help tremendously. The cautionary point when an organization decides to go forward with an audit is you have to be prepared to deal with the information that comes out of the audit, the results of the audit. And there are certain ways that you should structure the audit to ensure that you are not creating any greater liability by virtue of doing the audit, because ultimately and presumably the intention is to do the right thing by fixing the wrongdoing. So again, before you get started with the audit, just make sure that senior management is aware of the sorts of things that could be found if you have a sense of the things that are going on, which is actually giving in-house counsel or compliance a need to do an audit. Give management a heads up of this is what we might find and this is the scope of it. I mean, we're talking about 600 employees going back 2 years, possibly 3, and this is the dollars that we might be dealing with. It's important that once you've decided to conduct an audit, that you think about who's on that audit team, because you really only want to have the people who are there with a need to know, and obviously can keep the information confidential. So you have your HR person, your payroll person, and I always recommend legal, whether it be in-house counsel or outside counsel, because the records that are created as a result of the audit, this investigation, could be discoverable. So it's helpful if ultimately the audit is being performed because the organization needs guidance on whether their practices are in compliance or not. They need legal assistance, and rightfully so, they should benefit from the attorney-client privilege. So it's important that you do have a lawyer on the team, and the audit and investigation should be led by the legal person on the team. And that will help to ensure that the records are preserved under the privilege. You want to make sure that those who are on the team sharing communication, creating the records, clearly mark the records under the attorney-client privilege or the work product privilege doctrine, and that the work really should be directed by legal. And if as the lawyer you are instructing payroll to look into something, or HR, when they get back to you or when they correspond with each other, again, a practical tip is ensure that when they're looking for information, they indicate in their email or memo or whatever it is, at the direction of counsel, I need to collect the following information. And this helps to curb the dispute over what's privileged and what's not privileged. Things to just keep in mind in terms of the scope of the audit. Frankly, it's everything that we talked about in today's presentation. You want to look at the classification. Make sure that your workforce is properly classified between exempt and non-exempt, because if you have individuals who have been classified as exempt and the organization got it wrong, we're going to owe them overtime. And the challenge with that is if they have been exempt, an organization probably has not kept track of their working hours. So that creates a real practical dilemma there. You need to look at any off-the-clock work. such as pre- and post-shift working activities. For example, what's a hot area you see in case law is in a call center, employees having to report to work before their scheduled time to boot up their computer, so there's waiting time there. Also, again, the idea of pre- and post-work shift activities could be your donning and doffing situation. What is indispensable for them to do in order to prepare for their shift? Security screenings, Robert referenced that in the case earlier. Travel time, if the travel time involves someone picking up some tools or supplies on their way to work, if that's something that they were asked to do and it's part of them being able to perform their job, it's probably going to be deemed compensable work. Another example is any type of training time that's mandatory. While yes, the argument could be made that, wow, this is benefiting the employee, but if they need that training in order to do their job and advance the work of the company, that's paid time. David also mentioned this earlier. You need to look at meal breaks. Are they interrupted? Because if they're interrupted, that may not qualify as a bona fide meal break, and that you may have to go back and pay them for the full time. Rounding is another hot issue. There isn't enough time to really get into the particulars of that, but you have to look at whether your timekeeping practices include rounding and any automatic deductions. Regular rate also. Make sure that the calculation of regular rate is in compliance. There are certain elements of it. It could get quite complicated, especially if you have various types of bonus schemes, whether they're discretionary or non-discretionary, if they're tied to some particular objective, and if you meet it, you get the bonus. You may have to factor that bonus into the regular rate. And then certainly you want to make sure that you review your payroll records and ensure that you have the records that you need, which is one of the questions here. Maybe it's a great question for David, but I saw earlier there was a question about what happens if you don't have the proper record keeping. I will shift that question to David, but I do see that we're out of time. It's 3:30.
Well, I just want to thank you, Sharon. I just wanted to say that the Division of Wage and Hour Compliance within the Department of Labor and Workforce Development conducts time and payroll inspections every day. There's a section in the Wage and Hour law that gives the Commissioner, the Director of Wage and Hour, and their authorized representatives the authority to conduct time and payroll inspections and to enter places of covered employers at any time for any reason. We recommend that covered employers comply with requests for records, as there is no legal basis for refusing to comply. An employer does have a right to due process and to disagree with our findings, but the employer must comply with a request to produce records. And I would just say about off-the-clock work for non-exempt employees, that would be illegal. They have to be paid for all time worked. And I'm not talking about just donning and doffing. I'm talking about actually working. Thank you.
Just a real quick final point I wanted to make is ultimately, once the audit is concluded, the organization is going to be tasked with a difficult decision. If they do find that they were in non-compliance, how do they correct it? Do you do it on a go-forward basis, or do you look back? Just a final point, you can enter into private settlement agreements releasing a company of FLSA or state wage and hour laws. A settlement will only be, a release will only be enforceable if the settlement was a result of a supervised settlement with the Department of Labor or as a court-approved settlement through actual, action in court. So unlike other types of liabilities that you can potentially have released through a private settlement, you can't do that in the area of wage and hours. So that it does become a challenging area for an organization where they do find themselves in trouble. And Robert, I know that we're out of time, but I'm not sure if you want to comment on that at all.
Well, could I just say one thing very quickly? We cannot prejudice an employee's rights to seek additional wages if we find that they're due, and we are obligated legally to try to recover any wages that are found to be due.
Chrissy, we just have a couple minutes and a lot of questions. So, Robert, Sharon, Dave, did you have a couple you'd like to address?
Well, there was a question before about full-time employees and if working less than, is an employer required to give full-time employees 40 hours, and my response is that the employer defines what's full-time. We don't. We just define that you have to pay overtime to non-exempt employees after 40 hours in a week.
Okay, great. Thanks, Dave. Rob, what about you? Sharon?
Sure. I think that one of the, I don't know if Robert's on mute, but one of the questions that did come up had to do with unpaid internships in the area of government employers. Definitely reference the fact sheet because there is an exception relating to nonprofit. This is actually an area that Robert and I had discussed. We expect probably not too far in the future that we're going to see some crackdown or some explanation or limiting applicability of whether interns in a nonprofit organization are automatically could be viewed as unpaid. But definitely reference the fact sheet because there is a point there made about nonprofit organizations.
Hi, I was on mute mistakenly. I thought I was speaking and I wasn't. Sorry about that. One of the questions early on is whether an employer can withhold taxes from the settlement proceeds in a wage and hour case and must take payroll taxes. The answer really depends on what the settlement's for. If it's wages, it absolutely is subject to withholding and payroll taxes.
Right.
If it's liquidated damages, my understanding of the IRS's position is that you can treat that as 1099, non-payroll, non-wage income. Another question involves household employees and whether or not they're exempt from the overtime requirements. And the rule, as I understand it, is that unless the household employee is living on the premises, they're entitled to overtime. They're generally considered non-exempt.
Well, what about the conversion of a contractor? I thought that was an interesting question. Did you see that one?
I didn't say it.
If you can, the conversion of a contract employee to a salary employee, what considerations an employer should address to ensure equitable treatment of these salaried employees, such as payment for equipment and use by the employee? Robert, did you have any insights on that, or Sharon?
So I have to say this is a new one from my perspective. Typically, my general rule is that if you're making somebody an employee, the employer is providing the equipment. The way I read the question is that you've got independent contractors who had their own equipment. They're now being brought on as employees, and what do you do about the equipment? From my perspective, and I understand that the specific question relates to fitness professionals, the employer should be providing whatever it is the employee needs to do his or her job. Whether or not the employer wants to buy some of the equipment from the former contractor is an interesting question. There's certainly no obligation to do that. Whether the employer wants to do that, a fairness concern is fine. I mean, I think the bigger concern when you convert somebody is that an admission that perhaps the person was misclassified in the first place? So that's something you'd want to think about.
Okay. All right, Sharon or Dave, any final quick words? And we have to conclude. No?
No, I can't think of anything.
Okay. All right, Sharon, anything? Otherwise, we'll turn it back to Vanessa or Kathleen to wrap us up. Okay, let's wrap it up. Vanessa, Kathleen?
Thank you, and thank you, Sharon and Rob and Dave, for an excellent presentation today. Thank you, everyone, and have a great day.